Be honest and advise your client to be honest. While drafting a civil suit or a writ petition, advocate should disclose all the relevant facts. Even in drafting of criminal cases, one should disclose all relevant facts. An important fact which should not and cannot be concealed is a previous litigation on the same issue or some issue touching the main issue of your case. For example, if a bail application is previously dismissed, then you must fairly say that this is the second or the third bail application, as the case may be. If the same civil or constitutional issue has been previously raised by you and decided this way or that, then you have to disclose that fact into your pleading. Otherwise, High Court is not going to give you any relief. While arguing cases on behalf of respondents, if you come across any concealment of facts by the opposite party, then please take advantage of this ruling. K. Jayaram versus Bangalore Development Authority, 2022-12 SCC 815. It was held, while invoking writ jurisdiction, petitioner must approach court with clean hands by disclosing all material facts within his knowledge. The appellants therein had filed a writ petition before the High Court for cancellation of allotment of sites to the respondent numbers 5 and 6. According to the appellants, though property of father of the appellants was acquired by BDA, 8 guntas of land was left out from acquisition. But BDA filed a reply inter alia objecting that earlier a civil suit was filed for permanent injunction, contending that these 8 guntas of land had not been acquired. But that civil suit was dismissed, and the appeal was also dismissed, and the appellant had not disclosed the dismissal as well as the appeal in this writ petition. So the Supreme Court held, High Court, to check multiplicity of proceedings pertaining to the same subject matter and to stop the menace of soliciting inconsistent orders through different judicial forums by suppressing material facts, either by remaining silent or by making misleading statements in the pleading. In order to escape the liability of making a false statement, the parties have to disclose the details of all legal proceedings and litigations, either past or present, concerning any part of the subject matter of dispute which is within their knowledge. In case no legal proceedings or court litigations were or are pending, they have to mandatorily state so in their pleadings in order to resolve the dispute between the parties. Supreme Court held, since the appellants have not disclosed the filing of the suit and its dismissal, and also the dismissal of the appeal against the judgment of the civil court, the appellants have to be non-suited on the ground of suppression of material facts. They have not come to court with clean hands and they have abused the process of law. Therefore, they are not entitled to the extraordinary, equitable, and discretionary relief. So, my dear lawyers, be honest and get maximum relief from courts.